Okay, welcome back to the Legal Lowdown. I am your host, Matthew R. Carpenter, an attorney, and today's topic is something really fascinating. It's about creativity, but also about the law and how technology is shaking everything up. Think about something that looks artistic, maybe beautiful, like wildflowers that just happen to sprout in a design so perfect you try to copyright it. Or maybe even something an animal does, like a rhino using its horn to scrape something into a tree that looks like a Basquiat. Weird, right? But the point is, no human hand is involved. And that's the key issue with artificial intelligence. We have AI nowadays generating images, writing songs, crafting stories that feel, well, remarkably human. But that creates a huge legal tangle, doesn't it? Because if a person didn't make it, can you actually copyright it? That's the core question that we're looking at in today's podcast. And then there's the other side. What about all the data these AI systems learn from? So much of it is already copyrighted material, right? So today we're going to unpack this. It's like AI is walking this legal tightrope and nobody's quite sure where it leads. Let's start with the basic. Copyright law. It's meant to protect original creative work. It gives creators rights, and there's a kicker though. The main law in the US, the Copyright Act of 1976, it has this really crucial requirement that AI companies are going to hate. The work must be created by a human author. So human is the key word. That sounds like a problem for AI, doesn't it? That language forms the central battleground that leads us straight into a key 2023 case called Thaler versus Perlmutter. Stephen Thaler was an inventor, y'all. He was not an artist. And he created an AI ironically called the Creative Machine that apparently generated stunning images. Thaler tried to copyright the work by submitting an application to the US Copyright Office, but he made a huge mistake. He listed the AI as the author instead of himself. Bad move, bad move. So, given the Copyright Act's human authorship requirement, what do you think happened? Well, the US Copyright Office said no, your application is not approved, flat out. And a federal court agreed. Why though? Just because the author wasn't human. The court looked at the Constitution, statutes, and previous rulings and concluded copyright is fundamentally about authorship, human authorship, and machines just don't get those rights. So much for our artistic rhino. Poor rhino. Anyway, you get the point. AI alone can't be an author. But my lawyer senses are tingling. What about AI plus a human? That seems like the more common scenario now. And the Thaler ruling didn't really settle that. It kind of cracked open this tiny window, leaving this big question behind. How much human effort do you need to put in alongside the AI before it's protected? That's what OpenAI and creators using ChatGPT are asking right now. How much human needs to be in a prompt or in the editing? And the Copyright Office actually weighed in on that in early 2025. They sort of hinted that maybe existing law could cover AI-generated work if there's a clear level of human creativity that shows up. In short, the Copyright Office basically just asked, is the work fundamentally human authored with the computer just being a tool or an assisting instrument? If so, you AI creators might be Gucci. But the problem, people, is this whole human element. It still sounds pretty vague, like a nebulous legal fog. Okay, so that's the authorship side of things. But let's switch gears to the other big issue, the training data. Because these AIs don't just invent things from nothing. They learn from massive data sets. And massive, believe me, is the right word. These data sets are often filled with copyrighted books, articles, photos, you name it. So how do AI companies get away with using all that data? All that protected, proprietary, precious data? Don't they need permission? You would think. But normally they rely on a legal exception called fair use. The exception lets you use copyrighted stuff sometimes if your use transforms the original work in some way. Think like commentary, parody, criticism, or for AI companies, innovation. But the problem is always a problem. Transformative sounds subjective, especially with AI, highly subjective. And we saw that tested recently, actually this year, 2025, as a matter of fact, in Thomson Reuters versus Ross Intelligence. Ross created an AI for legal research, and they trained it using proprietary legal summaries from Thomson Reuters. The court looked at it and said, nope, this ain't it, fam. This is not it, Ross. But on a deeper level, the court basically said Ross was stealing the content. Even using bits verbatim, just remixing or repackaging wasn't enough to count as fair use, which is a big warning shot, right? Okay, so that sets the stage for a really big case that's fresh off the boat. New York Times versus OpenAI. Absolutely huge case. NYT is arguing that ChatGPT, which is operated by OpenAI, illegally copied millions of its articles for training. They claim it even spit out their content, sometimes word for word, as Soulja Boy would say, bar for bar, which hurt NYT's business. And OpenAI's defense will likely be fair use. They'll probably argue that their use of the copyrighted material, the copyrighted New York Times articles, is transformative. Maybe similar to how that Google Books case went back in 2015. If you don't know about it, Google scanned millions of books to make them searchable, and courts called that transformative. But is summarizing articles or mashing them together the same as creating a search index like Google did? I don't know, it kind of feels different. And that's the core legal question here. Does tweaking words, changing the format, mixing 20 articles into one paragraph, is that really enough transformation to be protected from copyright infringement or even to obtain a copyright of your own? Nobody knows for sure yet. And the Copyright Office weighed in on this too. They've been releasing these reports in various segments. Report 1, Report Part 2, Report Part 3. We're digging into Report Part 3 right now. It came out in May 2025. It basically said that fair use likely doesn't apply if these large language models like ChatGPT are just, mimicking the stuff they were trained on, especially if the AI systems generate something called substantial protectable expression from the original content. Substantial protectable expression is important here. It basically means copying chunks of protected works, again, thank you, Soulja, bar for bar, and that's bad. But here's the scary part I read about. The U.S. Copyright Office report also hinted that users might be liable. That was the plot twist for me. It suggested that if you, the user, are benefiting from or sharing AI output that infringes copyrights, you could potentially face claims too. So it's not just big tech companies, right? Okay, but let's get real for a second. Let's get legal for a second. When courts look at fair use, what are the deciding factors? There are 4 in particular, but the Copyright Office highlighted 2 as especially important for AI. First, the purpose and character of what's being used. Is it really transformative? Does it add something, some new meaning or value? Or is the AI output just derivative, just remixing without adding value? That's a problem. The purpose and character, that's the first factor. The second factor, or second in terms of importance, is effect on the market, the effect that the copying has on the market for the original product. Does the AI tool or its output harm the original creator's ability to make money from their work? Does it replace the market for the original? If yes, that's a big strike against fair use. So the purpose and character of the work and the market are key. And the bottom line seems to be that fair use isn't some magic wand. It's not a get-out-of-jail-free card. The fair use exception is really specific to the situation, and the stakes just got a lot higher for AI developers and for people using their tools. It really feels like we're at a crossroads. I know what that feels like. So summing everything up, I really hope this podcast highlights a fundamental tension for you. When you use AI, are you genuinely creating something new, something innovative? Or are you perhaps, without even realizing it, buying into imitation, just repackaging the creativity that already exists? And the answer to that question could shape everything, people. This stuff is a big deal, fam. Who owns culture? Who owns creativity? Maybe even what the future looks like. Just something to think about. Until next time, and thank you for joining me on this episode of The Legal Lowdown.